Okay, our screen is now complete with both counsel. Mr. Elliott, my understanding is that you are here on behalf of the appellant. And if so, did you wish to reserve time for rebuttal?
Yes, please, Your Honor, 5 minutes.
Okay. I will let you know when you get there. We are ready to begin.
Thank you. May it please the court. Good morning. I'm Greg Elliott from Elliott Berger, PA in Seminole. We represent the appellants Brad Berg, Tina Berg, BTJJ Holdings, and RBC Conservation Corp. We've raised and briefed 5 issues for the court's consideration on appeal. While I'll attempt to briefly touch on each one of them in the allotted time, because we believe the first issue is such far-reaching importance, I'll devote primary attention to that. In Waverly 1 and 2 v. Waverly, cited in our reply brief, the court explained that the principles governing contractual interpretation are well settled in Florida. Generally, the intention of the parties to a contract govern its construction and interpretation. The intent of the parties by their use of such terms must be discerned from within the 4 corners of the document. In the McCaw v. Gross decision, also cited in our reply brief, citing to the Supreme Court's decision in Blackshear Manufacturing, the court explained that to ascertain the intention of the parties to a contract, the trial court must examine the whole instrument, not just particular portions, and reach an interpretation consistent with reason, probability, and the practical aspects of the transaction between the parties. Confining oneself to the 4 corners of the declaration, appellants submit that it is the developer's plainly expressed intention that management of activities allowed in Tract A was to reside with the Sea Pines Homeowners Association or its successors, with one inviolable exception. That is, the association or any successive owner could impair the lot owner's express easement for surface water drainage into the Tract A stormwater facilities. This is an interpretation that properly expresses the intention of the developer when the instrument as a whole was authored back in March of 2002. And it is an interpretation that is consistent with reason, probability, and the practical aspects of the development transaction. An interpretation of the declaration, which finds that it was the developer's intention for each lot owner in Sea Pines to set their own individual rules for access and activity in Tract A, as the judgment on appeal does, is not consistent with the plain meaning of the language within the 4 corners of the declaration.
So just to cut to it, you would maintain that the Tract A is limited to the lot, I think it's 7, 8, 9 or 8, 9, 10, those 3 lots have access to Tract A?
Well, the intent was for the association to control it. Now, that doesn't mean everything is prohibited, but they can pass rules and regulations and what have you to constrain what activities go on in there. The presence of the 80-foot piece of boardwalk that is in Tract A is kind of a separate issue, and it relies on the permission or license granted by the association back when it controlled that access or that parcel. If I understand Your Honor's question.
It seems to me there's 2 fields of 2 camps here. On the one hand, you're arguing that the Tract A has a very limited access by the lot owners. Your opponent is saying that they should have broad and unfettered access to Tract A and enjoy the full use of the entire tract for all the homeowners. Is that too crude of a?
Well, I think it's a fair general view of it, but the point is,
figure out who's entitled. Is that easement for drainage or is it for something more than drainage?
Well, drainage is the one thing that no owner, be it the association, a successor, what have you, can impair. That's an express easement that's set forth in the declaration. Otherwise, what can happen, what lot owners can do within Tract A is intended by the terms of the declaration, including the bylaws and the articles of incorporation, to be manageable by the association, that was the intent, or by its successor. And the problem is exposure to liability. For instance, a lot owner puts a trampoline in Tract A. They can't control that under this easement the court's interpreted, and you can't insure property that has a trampoline. Riding ATVs in there, that's exposed as a liability. Minors riding around on ATVs, no control. And that's not what the declaration, what the developers intended by the four corners of the declaration. The intent was that someone can manage it, in this case, the association as the owner or its successor as the owner, can pass rules and regulations to allow reasonable activities in there. But there was no intent that that owner be hamstrung from making any management of that tract.
Okay.
It's not reasonable, nor is it probable, and this kind of goes to your question, Judge Black, that any developer of a condominium or residential subdivision would intentionally surrender complete control of a community pool, a fitness room, or such other typical common facility to the discretion of each individual resident to use as they see fit. Respectfully, while rendering the interpretation to oppose this broad perpetual easement as the trial court has, it's clear that the trial court actually recognized, if one confines oneself to the four corners of the declaration, the interpretation urged by appellants is in fact the correct interpretation. This is evident by the trial court's discussion in its order denying appellants' motion for rehearing, where the appellants' defendants had argued that the perpetual easement declared would not only restrain the current owner of Tract A, which the trial court clearly disfavored, from any ability to manage Tract A, that it would also hamstring any future owners of Tract A from reasonable management of the parcel. In response, the trial court declared that if Tract A were conveyed as the declaration and plat requires, the proper owner entity would be able to impose reasonable restrictions on use for the benefit of the lot owners. With respect, that can't be. A perpetual easement, now recorded in Pinellas County official records, indexed in the name of every lot owner, which easements puts the lot owners in charge of Tract A in perpetuity, won't simply disappear if Tract A is conveyed to another owner, proper or not. If the lot owners were to sit down and vote to reinstate the HOA tomorrow, there is zero chance that that association would accept ownership of Tract A subject to this easement. They can't control their exposure to liability. Similarly, there's zero chance that any public agency or utility would take ownership of Tract A with no ability to manage their exposure to liability. Respectfully, by its judgment, the trial court focused in on one generic and very commonly used phrase, use and enjoyment, mentioned a couple times in the declaration, in order to tailor an interpretation that it believed would solve one specific concern that was outside and separate apart from the matter of a straightforward contractual interpretation confined to the four corners of the declaration. That is, what to do about the developer's breach in failing to convey title for Tract A to the association or some other entity which the trial court considered proper. Attempting to resolve that issue, which has persisted in the subdivision for years and years, with no action by any resident to address it, is understandable. But doing so by writing a perpetual easement into the declaration that's not there by any fair interpretation, with the errant belief that it would only hamstring the current disfavored owner, is error. And we respectfully ask this court to review that judgment, or reverse that judgment on de novo review. The second issue we've asked the court to review is the trial court's finding and conclusion that the short piece of boardwalk out to state waters is within Tract A, significantly violated the broad easement rights the trial court had judicially declared. We submit in error. An action to enforce an easement or to remedy violation of an easement is a specific Florida cause of action. It implicates a number of affirmative defenses, including abandonment, adverse possession, laches, and the like. By this judgment, the trial court granted a remedy for such a claim, though no such claim had been pled by any party. The defendants had no opportunity to assert appropriate affirmative defenses, and critically, while such claims universally implicate questions of fact, there was absolutely no evidence offered at trial either way on such a claim. Appellants submit that by granting relief on claims that were neither pled nor approved, the trial court clearly erred and respectfully ask this court to reverse the judgment accordingly. The third issue on review is our request that the court reverse the trial court's finding that the officer of the HOA acted ultra vires when he gave lots 8, 9, and 10 permission or a license to permit and erect the portion of boardwalk that is within Tract A. The declaration and incorporated instruments expressly gave the directors and officers very broad authority for managing association property, including Tract A. While the officer could not transfer or dedicate an interest in that property without a vote of the lot owners, a license to use is neither a transfer or a dedication of a property interest. It's merely permission to use at the pleasure of the owner. With a license, just as the owner can permit the use, the owner can revoke that permission at its discretion. While any lot owner might have attempted some sort of legal action to challenge that officer's grant of permission, because it is not in fact ultra vires, the action would have had to have been brought within 5 years of October 30th, 2003, when the license was granted. However, no lot owner uttered a sound for 16 years. To the extent the trial court's judgment is grounded on the finding that the grant of permission was ultra vires action, we respectfully ask this court to reverse the judgment accordingly. We've also asked the court.
Is that argument based on the statute of limitations issue?
Say again, Judge, I'm sorry?
Is your last request based on the statute of limitations problem?
That is a statute of limitations issue, yes, Your Honor. Because, and this is a case cited in the brief, I think it's Conrad v. Young, cited in our initial brief, says that a cause of action such as this, no, I'm sorry, that deals with the easement issue. But yes, Your Honor, it's an action, any action to challenge that decision to allow permission by the association based upon the terms of the declaration would be an action on a written instrument. And therefore the statute 9511, I think it's 2B, applies with the 5-year statute of limitations. We've also asked the court to review that part of the trial court's decision that basically.
If I may, Mr. Elwood, going back to your last argument, help me out. The ultra vires argument, I think the appellee is taking the position that the developer continued to represent the HOA even after it was administratively dissolved and no longer existed. I think that was their point, that because his action after the fact, that's what caused it to be ultra vires. Can I have you address that?
Yes, Your Honor. Actually, I think because the permission was given October 30th of 2003, and the association was not dissolved until 2005, September, I believe. I think their argument has been that because the rules for voting set out in the declaration say that as soon as the developer no longer owns a lot, they have to do the turnover meeting and turn over control of the association to the members. And then the members vote their own directors and officers and what have you. The problem is that's not an automatically effectuating provision. So I think it's the articles or the bylaws or articles say that the officers and directors serve until they are replaced. Nobody did anything to replace them. Nobody called for a turnover meeting until 2006. And at the turnover meeting, they voted not to reinstate the association at all. And it was at that turnover meeting that they resigned.
And I think one of the things that they also bring out the fact is that they should have had a vote. It should have been brought in with a vote, as opposed to having one individual directing and giving that permission, part and parcel, before the association, got dissolved. And how do you address that?
Well, I agree that that's the argument they're making. The problem is they didn't make that argument in 2003 or 2000. They didn't make it until 2019. And if their claim was, again, the act has to be ultra vires to dispose of the statute of limitations issue. And there's nothing to suggest that it is in fact ultra vires. The association had absolute authority to govern and manage that property. So long as they didn't dedicate or transfer a property interest, which a license or permission is not a property interest, the owner now could revoke that permission to have that deck there today, or at any time. So as long as they didn't dedicate a transfer interest, it didn't require a vote of the members. It only required the action of the appointed and serving officers and directors.
Council, you are at 15 minutes.
Thank you. I'll preserve the rest of my time and rely on the brief for the other two remaining issues.
Okay, Attorney Vesely, the floor is yours, counsel.
Good morning, your honors. May it please the court. I'm Brandon Vesely from the Florida Appellate Firm. I'm here representing the appellee, Michael Scurry. Your honors, taking up this first argument where the trial court interpreted the governing documents, the trial court made a very, very good finding that the documents, when read in total, allowed for use and enjoyment of the Tract A. If you look at section 1.6 of the declaration, where it describes common areas and says that common areas shall mean any property, including the surface water management system area called Tract A, and that the identification and for the in that these areas are for the common use and enjoyment of the owners. Counsel for the appellants, Mr. Elliott, wants to limit it just to what is stated in section 2.1 of the declaration, where it talks about the easement for drainage in and to the surface water management system area. But that only talks about enjoyment. It's an easement of enjoyment. Section 2.2, if you go even further, says the delegation of use. And this is what the court really...
Counsel, I was kind of surprised and disappointed that the court order doesn't even reference section 2.1, which seems to me to be pertinent to the case. Section 2.1, entitled Owner's Easement of Enjoyment, provides that every owner shall have the right and easement for drainage to get into the surface water area. It shall be appurtenant to and shall pass with the title of every lot. Court did nothing with that.
Your Honor, I've read so many of these documents. I thought that court actually did, but it was a stipulated fact in this case. Everybody is in agreement that provision exists and has relevance in this case. However, if you look at 2.2, the delegation of use,
Right.
the surface water management system area and facilities are to be enjoyed by all of the owners of lots in the subdivision. And so that is the delegation of use. So you know, when you look at the language of the declaration, 2.1 talks about enjoyment, 2.2 talks about use, and it says in the delegation of use that this applies not only to the owner of the property, but his family, his tenants, and his contract purchasers who reside on the property. And there would be no, if it's only for drainage, if it's only a drainage easement, there would be no need for anybody, tenants, family members, or contract purchasers to have use of a drainage easement. The drainage easement was there for the benefit of the owner, not necessarily his family members, his tenants, or contract purchasers.
And
So,
Mr. Venn, just to double check, you said in response to Judge Black's question, the 2.1 issue, you said that was a stipulated fact, that it was not an issue in this matter. Could you explain that a little bit more?
before the trial, the parties sat down and they stipulated to a number of things, and all the parties stipulated that these provisions were part of the declaration. That's one of the things that they stipulated to. They also stipulated some other things as well. there's a whole list of stipulated facts. In fact, when the court was addressing these things in its final judgment, it referenced that certain things came from stipulated facts. And so the 2.1 and 2.2 were part of the stipulated facts. I mean, nobody's contradicting that that's actually what the declaration says.
Thank you, sir.
Okay. So, I mean, the judgment correctly recognizes that the inclusion of individuals who are not lot owners, the family members, the tenants, to the list of those who may be given a right of enjoyment to the right of enjoyment and use to the surface water management system suggests more than the enjoyment than just simply the use of a drainage system. Again, why, the court said, why would a family member or a tenant require a delegation of the right of enjoyment to merely and exclusively a drainage easement?
I don't know if this is on record or not, but what exactly enjoyment are they after? What does that mean?
Well, Your Honor, this came up when my client actually purchased his lot in the property, and he wanted to go out there and trim some of the trees, some of the bushes and things that were in this drainage easement area, in this tract A, and he was prohibited from doing that because this ultra virus act of the owner of when the developer sold the tract to the Bergs and then subsequently to these other entities, or transferred to these other entities, they were prohibiting anybody from going into this area. And so that was the beginning of it all. That was the start of it all. But actually, Your Honor, I mean, they have the right to do anything they want in there. I mean, as far as, within reasonable limitations, if a homeowners association place reasonable limitations on what they can do in Tract A. But this is right next to a water area. Obviously, there's riparian rights that are adjacent to this Tract A. So they should be able to access it and go through it. And, what's happened is these lots 8, 9, and 10 have acquired was basically an exclusive right to have a boardwalk across this Tract A and out to a observation dock, if you will, that, again, they're exclusive. And another provision I think is very important in the declarations is it's in the again, it's in the definition of a common area, and it says the common area shall mean the property owned by the association together with any improvements constructed thereon. So now you have a boardwalk that is on the Tract A common area, but my client and all the other lot owners that are not part of 8, 9, and 10 are excluded from using that boardwalk. And it's actually it becomes part of, because of it's an improvement on Tract A. So it's a situation where this exclusivity is preventing my clients from their use of Tract A. And why should they have the exclusive right to control that? This tract A wraps around the entire property. It's a very large area. Why should three lot owners have the exclusive right to use that Tract A, to transverse that Tract A, and to prevent other lot owners from access to it? I think the letter that's in the record, Your Honor, was from the Bergs on behalf of their conservation group, and it said, without permission from RBC Conservation Corporation, nobody can go more than a foot or two into the Tract A to even do anything. If you want to clip your bushes, you have like 1 to 2 feet. So what's happened is these 3 lot owners have taken complete control over this Tract A and are using it to their benefit, to the exclusion of the other lot owners, which is completely in violation of what the declaration and the plat required in the beginning of this situation. And how did they obtain that? They obtained it through the ultra vires acts of the developer. The developer had no right to do any of these things. The developer—
And that was my question, Mr. Vesely, when I was talking to Mr. Elliott. My understanding is, in reviewing all of these declarations, is that the developer had, in order to convey what he did, he needed the approval Because at that point, the
That's right.
association was still intact. Is that correct?
That
It
is
was
correct.
after the fact that they disbanded, but at that time, and I think that's the position that was brought before the court, that his failure to get approved, 2/3 approval, that's what constituted an ultra virus act, which then it goes counter to their argument that the statute of limitations have run. Am I reading that correctly?
You are, Your Honor. And ultra-virus acts are not bound by the statute of limitations. Again, in this case, it's not about like the cases that have been cited by opposing counsel are cases where there's a developer that hasn't done something. This was, they took an action that they had no right to do beyond turning it over. They had no right to then permit somebody to violate the declaration to allow, you know, 3 of the lot owners, to the exclusion of everybody else, to build a boardwalk to an observation deck when there's nothing in the declaration or the plat that would allow that. So they're taking a step further. This isn't just, you know, you should have turned over the right. If this was a lawsuit about whether they should have turned it over, you know, turned over tract A, the statute of limitations might be a valid argument, but it's not about just that. It's about what they did in addition to that, which they had no right to do. Complete ultra-virus acts. And, you know, and it doesn't just stop there, Your Honor. It's building the boardwalks, allowing for the, supporting the application for the observation deck itself, which is a dock. And it's also later, you know, this defunct corporation, Sarasota Woods, comes out of nowhere and decides to sell, you know, in 2013, decides to sell the entire tract to the Bergs without any vote at all. They would need 2/3 vote, and they didn't even do it right. The declaration has steps that have to be followed. If there's not going to be a homeowners association, then they have to first offer it to a governmental entity, which they didn't do. And then secondly, if the governmental entity turns it down, then it has to be offered to a nonprofit that's akin to a HOA. Well, the Bergs were individual people, they're private entities. They subsequently, in the course of this case, tried to correct the action by creating a nonprofit, but the nonprofit didn't exist when the land was transferred to them, was completely done improperly. So, you know, this Sarasota Woods Realty, they never did anything they were required to do in this association. They didn't turn it over when they're supposed to. They allowed the HOA to you know, go defunct because they didn't file corporate documents like they're required to do. They completely, and then to turn around and then to allow the boardwalk and the observation deck, limiting it just to 3 lots, to the exclusion of all the other lot owners. It's just been done improperly right from the start. So, you know, again, this is, you know, there's a statute of limitations argument on the table. Judge Black picked up on it. The problem is we're not arguing what was argued in those cases that have been cited. We're not arguing that they just failed to turn over the association, which at that point you could make that argument. They actually took it a step further and started doing things that they were never properly authorized to do. It's about authority.
Before your time runs out, I wanted to get your thoughts on the second issue as well. Whether the trial court granted relief not requested, but
Yes,
declaring
Your
that
Honor.
the walkway observation dock constitutes a significant continuing violation.
Yes, Your Honor. So our argument is, and I think it's correct, is that argument was actually pled. Those arguments were actually pled by the appellants, by the counter defendants. They're the ones that brought up whether we should have access to their dock and their boardwalk. Their claim, there's their counterclaim. It was their counter defendants. So if you look at the pleadings, and I'll specifically show you at the record of page 122, they actually pled that neither of these counter defendants, which are my clients, they're the counter plaintiffs, counter plaintiffs. They're the counter plaintiffs. My client's the counter defendant. Neither of these counter defendants nor any person nor any other person should enjoy any right of access, use, enjoyment, or maintain the subject observation deck absent the authorization and or consent of lot owners of 8, 9, and 10, lots 8, 9, and 10. So they're the ones that brought it up. It is true that our initial complaint was seeking access to this boardwalk that was actually on Tract A, but this became so much more. This became about whether we have a right to it. And they brought it up, and the court obviously ruled on it. And I think it was tried by consent at the very minimum, Your Honor. There's lots of evidence as to who has a right to do what. And Your Honor, I believe it was tried by consent, and it should be and the trial court was appropriate. We also asked in our pleadings, and they did in theirs as well, that the trial court should grant any further relief as may be just and proper. So there was, it was before the court, Your Honor. It really was.
I hear you.
Sorry?
Should I hear you?
Okay. Your Honors, so I also want to address the prevailing party issue. The trial court made 3 main findings that identified the plaintiffs as the prevailing parties. The trial court agreed with the appellee, the plaintiff, that the developer had taken ultra-virus actions and breached his fiduciary duty to all of the lot owners. The trial court also agreed that the appellee, that all of the Sea Pine subdivision lot owners had rights of access and use to the surface water management system area, Tract A. And the trial court also agreed that the appellee, the plaintiffs, that the owners of lots 8, 9, and 10 could not exclude the remaining lot owners from use of the boardwalk and the observation deck. Again, the court found that my clients had access to that boardwalk and the observation deck because it was the boardwalk ended at the observation deck, and it was the riparian rights of the homeowners in the association, the lot owners, to have access to that observation deck. And so those were the 3 main findings.
Is the observation deck the emphasis for some of this? Because it seems like Tract A lied dormant for years and nobody gave it a thought. It was overgrown when the Bergs bought it. Were other people trying to use Tract A at any point leading up to that?
I'm not aware of whether they were or not, Your Honor, but by using the boardwalk, it puts you out at the water's edge and allows you to exercise your riparian rights. So that's important. And again, the boardwalk and the observation deck never would have been built but for the Sarasota Woods Realty developer coming in and supporting that application when they had no right to do that. That was an association right. And the court recognized later on that they had an argument, the appellants had an argument that they ratified that. Well, the court recognized that the ratification was just for the ownership of Tract A, but that doesn't give them the right to do any of the things that they're claiming they have a right to do in Tract A. They shouldn't have complete control over Tract A. So that all that was ratified was basically a hollow title transfer to the Bergs and ultimately to RBC Conservation Corporation. Your Honors, I also wanted to point out that we have our own motion for attorney's fees. Motions for attorney's fees in this case are based on the declaration. It's on section 11.5 of the declaration, and it states that in enforcing any of the declaration, a lot owner or the association, but in this case it's the lot owner, by enforcing the declaration is entitled to their reasonable attorney's fees and costs. So if there's no further questions, if there's any further questions, I'd be happy to answer them.
I don't see any
Good.
on my screen, counsel.
Okay, we'll rely on our briefs for the remainder. Thank you.
Thank you. Mr. Elliott, you have 5 minutes remaining.
Thank you, Your Honor. Obviously much to touch on. First, this issue of the lot owner's rights to engage in activities in Tract A. It's not that they should be 100% prohibited from reasonable activities in there by anyone, be it RBC, the associate, what have you. The problem is by attempting to dispose of the fact that the tract is not owned by an entity that the trial court favored, disposing of that problem by creating this perpetual easement that, let's say tomorrow, and we don't know whether Sarasota Woods Realty tried to convey that tract to a public utility or an agency or what have you. We have no way of knowing that, but everybody was dead by the time we went to trial. I'll suggest that it's not likely that anybody's going to take on a piece of property that's just a burden and provides no benefit to the county or anything like that, but be that as it may. If any of those did take ownership of it, which is, again, they wouldn't, knowing that they have no ability to control their liability, that's really the question. Okay, say RBC owns it, and they say, don't go into Tract A without notifying us. And the lot owners sue them under this easement that's been created. Let's say Pinellas County Environmental Control owns the parcel now.
If I may, Mr. Eld, isn't the crux of this not what if? It just sounds like if you distill this whole case in one little thing, you have 3 owners who's taking the position they own this Tract A. They don't want anybody else to come into their property. And they're basically taking that position. And then you have now some of the others saying, wait a minute, we should have access to it. And that's how it all came about, where people started looking what exactly transpired. And all this then discovered, where you have this individual, this director, giving, this property without having approval to the Bergs. And I think what precipitated all that is regrettably these 3 homeowners, the Bergs, taking the position, this is ours. No one could come and step foot. And going through, and what the trial court did basically said, no, you need to go back at the very beginning. What was the intent? What was the whole basis of this? And went through in great detail, indicating this is what transpired. I don't know if oversimplifying it, but it just sounds like this is to distill it. This is what it appears to be. And here's your opportunity to tell me why I'm mistaken, Mr. Elliott.
Well, no one's ever denied that it's an extremely odd and complicated situation, and it created entirely by the developer, basically abandoning the project back in 2005. The problem is nobody did anything until the Bergs bought their lot. And they went and they looked and they saw they hadn't paid the property taxes in 7 years. They paid the taxes in exchange for the deed, plain and simple. Now, I think it's important to recognize that before this lawsuit was filed, and Mr. Gerdes spoke to this at trial, they wrote all the residents a letter saying, we're going to sue the owners of Tract A. Do you want to be a plaintiff with us or a defendant? And 12 of the 15 residents decided they'd just soon be defendants and side with that. Then again, and Mr. Vesely spoke to this in, I think, 2019, 12 of the, basically 2/3 of the lot owners joined in a resolution saying they were perfectly fine with RBC owning this parcel as opposed to no one owning this parcel. So it's—
Counsel, would you hold your argument there at that point? Because one of the judges apparently has lost audio.
Say again, Judge, I'm sorry.
One of the judges on the panel has lost audio. So hold on a moment. We're trying to make sure they can hear your presentation.
Judge Kuzama is muted.
Mr. Elliott, can you say something? I'm just checking my.
Okay, Judge Kazan, can you hear
Yes,
me?
Your Honor. Can you hear me now?
Go back. Can you all hear me? Can I?
I can hear you, Judge Kazan.
Okay.
I can hear you, Your Honor. Can you hear me?
Hold on a second.
Oops, now we're down a panel.
The wonders of technology.
You'll get no argument from me. I'm from the age of an inkwell and a feathered pen.
I can remember when I refused to accept a pager. I don't know what decade that was, but I think it was the early 80s. I was just, there's the judge.
Now I could hear you. I have no idea what happened to my computer, so.
Are you back, Judge Kazan? Can you hear us?
I could hear you all, and I don't know what happened. Well, lost all audio. I'm good.
Okay, well, at the very end, we could actually hear you, so you were sounding well at the end.
Am I hearable now? Okay, thank you.
Apparently so, and I stopped the clock at 4:15, just so you know where you were in your time.
All right. Oh, that gives me 35 or 45 seconds. I'll go quickly. I think and I understand your question, Judge Kuzan, but I think we have to stay with, when we're talking about interpreting this instrument as to whether it actually grants a perpetual easement, for that we have to stay within the four corners of the document. Dealing with this issue of we don't like the owner of Tract A is a separate issue, completely separate and apart. And quite frankly, I don't think it's an issue that the court can remedy. These 15 lot owners are the only people that can sit down and say, we're going to vote to reinstate our HOA. We're going to have Tract A transferred into the HOA, elect board members, elect directors, and go forward. The problem is with an easement that says the association no longer can control Tract A, it's the Indians are in charge, or the inmates are in charge of the asylum now, that would never take ownership of Tract A. Neither would a utility or an agency. So again, if we look at the four corners, it says the association can pass rules, can construct stuff, can do this, can that, what have you. And then says, but specifically, they cannot impair every lot owner's right to drainage in there. That's the proper interpretation. The question of what do we do about, we don't like RBC?
I need to let you know that the time has expired about a half a minute ago. I wanted to let you finish your last thought.
Okay, thank you, Your Honor.
I called it.
This is this is the problem all along, is what do we do about the fact that the developer didn't do what he was supposed to do? And just saying, well, we're going to put an easement out there forever that's going to make the property basically unownable by anybody is not the right answer. And otherwise, we rely on our briefs. I wanted to speak briefly to the prevailing parties, but I'll again rely on the argument in our briefs.
Thank you. Thank you both. Sorry for the technological interruption, but we don't go anywhere without Judge Kate.
Thank you.
Absolutely not. So we are now at approximately 10:20. The court will be in recess till, 11:20. We'll be in recess till 11:30. Thank you.
Thank you. Thank you, Your Honors.
Thank you.